we will continue with law of hire purchase part 2, only 21 slides, right? So what you will learn is that you learn about formation of hire purchase agreement. That this topic will be divided into 3: pre-contractual obligations, construction of the hire purchase agreement, and post-contractual obligations. Okay. So by the time we finish this lecture, this topic, you will understand about the hire purchase agreement, including the pre-contractual obligation and post-contractual obligation. Okay. So for this lecture, you will listen to many section provisions. Okay. And each provision actually has, it's like a story. Okay. It's like a story, like what to do, okay, who's responsibility, right? So let us go to the pre-contractual obligation, section 4. Okay. If you want to buy a car, you go to the shop that selling car, like Pro2, okay? So you will tell them like, okay, I would like to have test drive. So they will let you, and then you ask about the price, and you see, you can go there and then ask them for like, how much is this? And then the monthly installment that you have to pay, monthly installment that you have to pay, all those things, you can ask them to prepare and show it to you if you want to buy, right? And let's say they showed everything and then you decided not to buy. No problem. It's their duty, responsibility to do it according to the law. Actually, as a customer, we can ask them, when we want to buy, the Pro2 people, the Pro2 salesperson, they are so kind, tell us this, show us installment, payment, monthly, whatever. Actually, it's not that they do it voluntarily. It is a statutory requirement. It is required by the law. Do you know this? I think that we never noticed this until we learn hire purchase. Okay? So let's go to section 4. According to section 4, owner has to give a written statement to a prospect hirer according to second schedule. Okay? So basically, owner or the dealer, they have to give us, the customer, the information on the description of the goods and the summary of the financial obligation of us, of the prospect hirer. If you want to buy, you will be the prospect hirer, isn't it? So you can ask them, okay, how much should I pay? They will ask you how much you want to pay for deposit. If you pay more, then you pay less monthly. If you pay less deposit, like 10%, you pay more monthly. And they will calculate for you. And this is according to section 4 of hire purchase. Okay, if you haven't heard this, then listen to me. Yeah, they are not kind. The law asks them to do. One moment, please. Right. And section 4, subsection 3 says that you, the customer, right, you don't have to enter into the transaction. After they give you all the summary, show you how much pay, they calculate for you. If you feel that, no, I don't want, you don't have to enter into a transaction. This is what provided by section 4, subsection 3. You don't even have to pay any payment for the preparation of the service of the statement. They print out this. Nowadays they don't print out. Last time, yes, long time ago, they print out, they show us. I thought they were so kind, but actually no. This is section 4, subsection 3. And section 4, subsection 4 says that if they fail to provide what they're supposed to provide or fulfill their obligation, right? And the prospect hirer entered into sale and purchase agreement with them, that agreement is void. So it's like this, right? Section 4 say that hire owner or dealer, you have to show the payment to the customer. Okay, now section 4, subsection 3 says that, okay, customer, they show you everything. If you do not want to enter into the agreement, you don't have to. So you can say, okay, it's all right, sorry, thank you for everything. I saw it, I can afford. Ma salama, bye-bye, no problem. And they cannot ask you to pay a single cent for the service that they provide to you. And let's say that you, the customer, you want to buy. You go there to Produa and then they invite you, please, Miss Savitri, sit down, and then you sign agreement, but they did not show you the statement. They failed to show the written statement. They immediately bring you to the room and then you agreed to buy, you sign agreement without having a chance to look at the written statement. That agreement that you sign is void. Are you clear? You can write in chat. If you have issue, whatever, or if you want to answer, you can write in chat, okay? If you don't want to on your mic, difficult, then write in chat. So are you clear with section 4? Right. It's nice to learn law, isn't it? At least you know your rights. Have you known this before, Muzammil? Nama Muzammil kena petik, terkejut dia. Okay. Section 4A, subsection 1. Construction of the hire purchase agreement. Okay. 4A1 says it must be in writing. If you have oral agreement, it is void, and it's not just void. The owner will be guilty of an offense. Okay. 4B1. Hire purchase agreement need to be signed by the hirer or on behalf. You cannot leave blank form. Section 4B3, subsection 3. Failure to comply with the earlier provision, which means that section 4, subsection 1, 4B1, 4A1, you know, it will render the agreement void. Okay. One moment, please. Okay. Section 4C1C. Right? Information to be included in the hire purchase agreement, which means that if you have the hire purchase agreement, they have the template under Hire Purchase Act. What they have to do is that include all the information there. If they fail to include the information, that agreement is void. Section 4C1B. Okay. Let's say that it says that if you want to pay, you want to give other than money for the consideration. For example, you want to buy, but you say that, look, I pay 40,000 cash, another 30,000 I want to pay in gold, for example. Right? Section 4C, say, yes, you can, but you have to describe in the agreement. So they will write there, oh, okay, 40,000, 40,000 cash, which means that by the bank will finance, another 30,000 is by gold. Okay, fine. No problem. Just describe in the agreement. Okay. And if you buy more than one good, you need to have a separate agreement. Okay, you go to Produa and you decided that you want to buy car for yourself. I'm sorry, I love Produa. I love Malaysian cars. So, jangan kecam saya. So, so you go there and say, I need Akiva, red color for me, white color for my father. You want to buy 2. Fine. Have a separate agreement. Section 4D1. 4D2. If they fail to observe 4D1, the agreement is void. If they say that, okay, same person, okay, just and then same person, same bank, same amount, so have one agreement only lah. No need 2 agreement lah. So they just put, okay, chassis number 4134H / blah, blah, blah. They use one agreement. That agreement is void. It must be separate. Last time, if the customer, sometimes the customer forgot to sign or they failed to sign, you know, before we amend this act, okay, the court accept the practice, which means that if there is an agreement and there's no signature of the customer, still the court accept, right? You cannot say the agreement void, the court accept. But then they amend the act. See, 4B1, 4A1, this A, capital A, B, capital C, this is amendment. When they first come up with the act, this section is not here in this agreement, this act. After that, they amend. So the law is always being amending. When we feel that the law is not sufficient or the law is too old, we have to, you know, create a new law, follow other countries which has advanced law. So we will amend the law. So in this case, look at this Ming Lian Corporation's neighborhood. The court said that the hire purchase agreement was valid, okay, even though in the sale and purchase agreement, right, at the space where they're supposed to sign, there is no signature. Court says that, okay, no problem, it's still valid as long as it does not involve misrepresentation or fraud. So, no problem. But then we have this section 4B. So with the enforcement of 4B, the hire purchase agreement cannot be left with blank at the signatory part. Signature part cannot, execution part cannot be left with blank. It must be signed, must be executed. If there's no execution, nobody signed, the agreement is void. Post-contractual obligation. Okay. First, you have pre-contractual, what they have to do. And then the construction of the hire purchase agreement. You see, hire purchase agreement is governed totally by Hire Purchase Act. All right, what they should include, what they have to do. And now we have post-contractual obligation. Section 5 or Section 1, okay? What they have to do is that after you sign, after they sign, yeah, they release the money, and then the person, you can go get the car. They have to send to you a copy of the agreement and the guarantor within 14 days. If they cannot send to you the hard copy, nowadays they send to you soft copy agreement. Otherwise, the agreement is not enforceable by the owner. This is provided by Section 5, subsection 1A. See 1A. Last time we have 1, and then they amended 1A. Okay. And we have Section 5, subsection 3 says that if they pay any insurance, so they need to send you as the customer the insurance policy. Now look at the rights and protection of hirer. Who is hirer? The customer. Who is the customer? You, me, right? So what are the rights? What are our rights? Whatever provided under the statute. Which statute? Hire Purchase Act. Okay? So the rights and protection we derive from the implied condition and warranties as to the goods hired. Okay? So condition and warranties, we refer to Section 7 of the Hire Purchase Act. Okay? Condition and warranties to be implied in every hire purchase agreement. In general, the implied condition and warranties are similar with Section 14, 15, 16 of SOGA. You haven't learned SOGA yet, so I will teach this under SOGA, Section 14, 15, and 16, because I do not want to repeat, so we will have repetition. So no need repetition. Wait for this, we will go for SOGA after your activities. But then I'll share with you a bit on implied condition. Okay. What are the implied condition? The owner has the right to sell the goods at the time when the property is to pass. Section 7, subsection 1B, which means that the owner cannot sell you the car and then later on something happened. The owner say, no, I'm not the owner. Right? So implied condition here means if the person are selling the car, it means that that person is the owner and has the rights to sell the goods, the car. Okay? And we can refer to the case of Ahmad Ismail, My Motor Company, and another. In this case, the court held that the title could be passed to the plaintiff under section that is equivalent to section 7(1)(b) HPA 1967. All right? Which means that, if you are the owner, which means that the legal owner, real owner, you have the rights to sell the car. When you have the right to sell the car, you will provide good title to the buyer. Good title here means nobody can come to the buyer and say, wait, this is mine. It's like that, okay? So, this is an equivalent to section 7(1)(b), okay? And then, the quality must be merchantable quality, right? And merchantable quality means here, if you buy a car, it is in good condition. You can open the door and you can sit inside the car. It is so nice. It's not like when you try to open the door, you open the door and suddenly you hold the door, what we call it, the things, the handle took off. You try to open the door of the car and the handle took off. Like that, or you start the engine, suddenly you hear the sound as a lorry engine, that is not merchantable quality, right? And we imply this. The moment you buy, it is merchantable quality. It must be in good condition, worth your money, right? However, we cannot have this implied condition if number one, you've been there, you check the car, you examine the car, and you check every single thing, and see that, okay, you agree to that. You go and check, you start engine, the engine sound like a lorry, but still you want to buy. After you buy, then you say, sorry, engine like a lorry sound. You cannot do that, right? If you have checked, then you cannot complain, right? B, if the goods are used item, second-hand item, then we don't have like the right, like the first-hand item, okay? And then the owner, now see, we have three situations here where you cannot claim for implied condition. You cannot claim, right? Number 3, when the owner already told you, the owner come and say that, bye, look, this car is nice, but it sounds like a lorry. Are you sure you want to buy? It's a new brand car, but it sounds like a lorry. And you say, okay, no problem. And then you bought. And you will go home, you hear this lorry sound, and your wife also say that, what is this, you blah, blah, blah. And then you want to go there and say that this is not merchantable quality. It has lorry sound. You cannot do that because the owner already told you, look, it has this defect and you agree to the defect. Okay. Implied condition here means if the owner, the seller, they fail to fulfill this condition, right? You can cancel the agreement. You can rescind the agreement. This is condition, not warranties. Condition, you can cancel the agreement. Warranties, you can ask for damages. So this is implied condition. There are 3 situations where you cannot go and claim implied condition. Okay? A, B, C. Right. And there are 3 situations where you can go and claim for implied condition. That is number 1, 2, 3. Okay? Number 1, owner has the right to sell. Number 2, it must be merchantable quality. Number 3, good fits for hire purpose. Which means that when you buy, you go there and you tell the seller, salesperson, I want to buy a car, and the car must go fast but use very little gas. And they say, yes, Encik, sila datang sini. Come here. This is the car that you want. And you bought the car. And after that, you see, wow, 2 kilometers, you have to refill fuel. 2 kilometers refill fuel, you know, like the fuel is dripping. So it does not fit for your purpose. Good does not fit for your purpose. Implied conditions say good must fit for your purpose. Since it does not fit for your purpose, you can sue them and cancel the agreement. This is implied condition. Implied warranty, you have the right to enjoy quiet possession. We will learn under 14B of SOGA. Good free from any charge or encumbrances created in favor of third party. Be patient. We will learn this also under SOGA. Okay, I don't want to repeat. You can have a look at this, sale and hire purchase. What is sale? Different between sale and hire purchase. Now you maybe don't see this. Let us learn SOGA and then you come back here. You can see the difference. Liability of the owner and dealer for misrepresentation. What if the owner or dealer, they commit misrepresentation? Okay. Section 8 says that the hire, you, the customer, if there is misrepresentation, you know what misrepresentation by now. We learned this under contract, right? The hire is entitled to claim against the owner for misrepresentation. You can make a claim, okay? You can sue for damages against the dealer or the agent and owner and right to rescind the contract, to cancel the contract, okay? And you also has the right to be identified by agent or dealer for misrepresentation. If it costs you loss because of the misrepresentation, you can ask them to indemnify you, pay you back. Right, now, statutory rights of the hire. Section 9 says that hire, customer, remember, if you haven't even buy a car, but you have to remember this. Section 9 says that, do I have section 9 here? Okay. So we have 9, 10, 11, 12, 13, 14, and 15. Okay, come here. We look here. Section 9. Right to a copy of statement of financial position. Okay. You must have a copy. Hard copy or soft copy regardless. Okay. And what are the content of the financial position? A, the amount paid to the owner by or on behalf of the hirer. How much amount you paid. The amount which has become due. You know, they will tell you, okay, 2025, January, how much you have to pay. 2025, February, 2024, December. You know, they have that statement. C, the amount which is to become payable under the agreement. The amount derived from interest on overdue installment. Okay, if there is any overdue installment. Okay, and you know, if you paid and then after 3 months, after 4 months, you want to see the statement, you can ask them, I want to see the statement. Okay, I want a copy of the statement. They must give it to you. Sorry, if the owner has sent the hirer, okay, unless you already asked like 3 months back, you asked, and then every month you ask, then they don't have to give it to you, right? If the owner has sent the hirer a statement under this section within 3 months immediately after receive the request, the owner need not comply with such request. So 3 months sekali, okay. Monthly, tak payah bayar, the one tak payah bagi. Section 9, right to a copy of statement of financial position. This is 9.1. You has the right to request if you want to see the statement. Okay? Amount due, amount paid, interest due, whatever in the financial position. 9.2, section 9, section 2. All right. If the bank, financial, the owner failed to do so, okay, or they deny, okay, if they fail to do so, their right is being denied. What does it mean by their right is being denied? Okay, you know, the bank, if you fail to pay, they has the right to repossess the car. That is their right to repossess. But if they fail to give you the statement of the financial position, they cannot exercise their right. Okay, number here, 2A, to enforce the following. So what they will lose is that they cannot enforce the agreement against you. Okay, they cannot recover the good from you. They cannot enforce any contract of guarantee relating to the agreement. You asked for the statement on January. Until March, they have not given you the statement. And on March, you fail to pay. You default. April, you default. They haven't given the statement yet. Okay. The law says that if they fail to give the statement, they cannot enforce their right. So since you default, they suppose they can come and repossess the car, but they cannot now because they failed to give you the statement. Do you understand what I'm saying?
Yes, okay.
Okay. The owner cannot enforce any security given by the hirer in respect of money payable under the agreement or given by guarantor in respect of money payable under guarantee. Similar here. They cannot enforce any security. Okay. And look at number 3, section 9(3). Actually, if you ask for the statement, they fail to give for a period of 1 month, the owner, that is the financier, the bank, whoever it is, they have committed an offense. They are liable to a fine not exceeding 1,000 ringgit. They can be fined for 1,000 ringgit. Section 10, right to appropriation of payment when more than one agreement. It says that like this, you have 3 cars. All three cars you took loan from Maybank. Maybank is the owner of the car because the financial, okay? And now you have problem, you cannot pay. So you can tell them, look, Maybank, normally I pay 6,000 per month and my business is not okay. So what I will do is that I will pay 1,000 per car this month and next month. You can do that. Okay? You can, or you just give them money and say, okay, I only have 2,000, pay them. Please make proportion. They have to make proportion. Section 11. You must keep the goods in the place mentioned in the agreement. In our agreement, normally we put our house address. All right. So the car, the motorbike, the lorry, the aeroplane, whatever you buy must be kept at the address in the agreement. Aeroplane cannot. Too big for your porch. Okay. If you want to, the law says that if you want to move to another location, you must ask permission by applying to magistrate. No, actually nowadays what you do, if you buy the bike when you are at home with your parents, then you graduate, then you work in another state, you want to move to another state, call the bank and tell, look, I'm moving here, my address will be changed to this one. Okay, change the address in the system. Because the law say that you must keep at the address. Okay. Section 12, right to assign hirer's right under agreement. It says like this. Okay. You have the right to the car, right? Now you want to give the car to your wife. Okay. You just go and tell the bank, look, now I want to assign to my wife. Okay. The bank will check. Okay, sir, let me check. Okay, no default, no problem. Sign another agreement. Okay, they will sign an assignment to include your wife's name. Remember, you learn contract. You cannot simply change the term in the contract. You need another agreement, novation, remember? So here, hirer and assignee to execute and deliver an assignment. We stated that the assignee is personally liable. So in this new agreement, the car's name from your name as a hirer to your wife. If and then pay the balance of installment. Fine, you want to pay, you pay. Third party can pay. In contract, we learn that. Okay, consideration come from third party, no issue. Pay the balance of installment if there is any. Observe all condition of the hire purchase agreement. Pay reasonable cost incurred by the owner. Like the bank have to pay, right? They pay lawyer to prepare the agreement. Then you pay for that. Okay. Now listen, sometimes when people sell their car, they sell to their brothers, but they never change the name. They say, oh, it's difficult to change name because you see, I have another 50,000 debt. So my brother will continue pay. Okay, the brother continue pay until last month. I'm sorry, I give you a sad story. The brother died, and the name is under the sister. And the sister said, no, this is my car. The name is under my name. So now problem, isn't it? Or they sell to another person, their friend. And the friend never pay. The friend go here and there and then got what? Summon from the police. 330,000. And you say, no, this is not my car. I already transferred to my friend. No, you did not transfer, my dear. It's still under your name. Go to the bank. Sign this agreement. Then only you go to police and say, no, this happened, make police report. Problem, isn't it? Actually, we have a better way. Go to the bank. Sign this assignment. Change the name. Then they will continue payment. You have no more obligation there. They don't want to pay penalty. That's your problem. Understand? Are you okay so far?
Yes.
Sure?
Yeah.
Okay. The best part is that, the best part is that one person, real story, one person passed the car to his friend. His friend, this is foreigners, yeah, because from the previous university, there are many foreigners, so we've been mingling. And I have many friends from different countries. So this friend sent to another friend, and then the first person with the name on it died. And all the letters come to the first person children who are still here in Malaysia. They are foreigners, all foreigners. We're talking about foreigners. And the children now have difficulty to find the car, and they do not want to make a report police. They said that, no, we cannot do this. We don't know, blah, blah, blah. So, hassle, isn't it? Problem, isn't it? So actually, this is the way. Remember this. Anyone who want to do this, like, it's okay, we have, no, tell them, go to the bank. Or at least has your own agreement. But actually, the law say that go to the bank, then go to the bank. Section 13, passing of right by operation of law. Okay, now here you change when the person is still alive. Now, when the person died, the law will, upon the death of the customer, hirer, the rights, the title, whatever it is, passed to the personal representative. The personal representative will comply with the agreement. If they have, like, I'm not sure if they have it for car, like we have this insurance or takaful for house. If the owner, the hirer for house also, we have similar law, die, and then the representative does not has to pay anything. The insurance will cover, the takaful will cover. But for car, I'm not sure if they have. If they don't have, and then the representative will settle the payment of the car. Or maybe the person died, and then you can go to bank and say, look, the owner died. Now I am the legal representative, personal representative. What do? We want to sell or what? Make arrangement with the bank. Immediately pass the right passing off from the owner that who died to the personal representative. This is section 30. And if you want to settle the agreement early, yes, you can, no problem. You have to pay full purchase price. This is your right. Section 14 is your right. You have the right to complete early. So tell the owner, okay, look, give me the balance payment, how much I owe you, I want to pay. They will give you the net balance under the agreement. Net balance here means after they deduct the total amount paid, the statutory rebate for term charges, the statutory rebate for insurance, then they will tell you, okay, here, the balance, pay. Then you pay, then settle, okay? Section 15, right to terminate the agreements. Do you have the right to terminate the agreement? You see, COVID, you just buy new Mercedes and suddenly your business doomed. What to do with the Mercedes? Rather than, they sue you, blah, blah, blah. You think that, come on, I cannot afford the installment. Might as well I just terminate. Yes, you can. Section 15 said, yeah, you can terminate at any time. You can go and return the goods to the owner, to the bank, tell, okay, look, I cannot pay. Go there, surrender, tell them where to surrender and surrender. And then, once you surrendered the car, and then your friend asks, hey, where's your car? I've surrendered. And say, oh, come on, sell it to me. So you can go to bank and say, look, bank, I have a purchaser here. They want to buy. You know why? Even though you surrender, the loan is under you. You still have to settle the loan. Now you have a purchaser. If your friend buy, which means that he will pay to the bank, right? If the amount paid is more than your debts, the bank will give the difference to you. If the amount paid is less than your debts, then you have to top up. This is under section 15. Okay? Right. That's all. Do you have any question? This is Pashto proverb. Be beautiful yourself and you will find the world full of beauty. Okay? Any question? Anyone?